the economy, various improvements that India can learn from. The idea of our presentation is to also set a tone, because I think in the next 2 days we're going to be hearing in more detail and in more depth on various particular niches of arbitration and ADR. So obviously our role as the first presenters is to try and set a general framework for arbitration, what it is, why should one do it, where should one do it, most importantly, and how should one do it. Now many of you will probably already know the basic differences between litigation and arbitration, but I was specifically asked to spend a few minutes to try and recap some of the important differences. Many of you are practicing arbitrators, practitioners, so this might be a little old news for you, but I'll still spend a couple of minutes on distinguishing on some important aspects between litigation and arbitration. Obviously, as Nishith mentioned, also time consuming. So whether it's tax litigation, whether it's any other form of litigation, unless you are able to improve your judicial system, the speed at which courts can give you justice, arbitration obviously is preferred. So whenever a client approaches us to draft a document, I think the most critical aspect of drafting any sort of commercial agreement, whether it's a share purchase agreement, it's a joint venture agreement, is to first analyze what is the nature of that transaction, which party are you representing, and what is the probability of a dispute arising, and who is most likely to go to court. Obviously, you can't guess everything from the very beginning, but I think as lawyers, our role now is equally important from the perspective of doing a risk and probability perspective when the document is being drafted. Most of the times, all of us as legal practitioners, whether in private practice or in-house, will pay very little attention to the dispute resolution clause. And we're all guilty of it. So, it'll either be some sort of a cut and paste, it'll be some sort of a best practice that our colleague gave us, that last time we did this contract and, Singapore's a good place for arbitration, let's put that, and by the way, you should also have some sort of access to a court. But I think it's become more of a science, more of a psychological analysis. And once you determine that in a joint venture, the probability of both parties ending up in dispute is very high. In a private equity investment, as Nishith was mentioning, the probability of the private equity investor suing the company is very high. So once you understand that background, you explain that to your client or your internal client or your external client, you're able to decide whether you want to go for litigation, you want to go for arbitration, or you want to have a hybrid clause, and how that should be drafted. Obviously, we have the rules of procedure, and now with in litigation, you have to obviously follow rules of evidence, you have to obviously follow the civil procedures, and there is no derogating from any of that. So that does add a lot of time, a lot of procedural burden and evidentiary burden to your matter. So that is another reason why you may prefer arbitration. But at the same time, if you're looking at quick relief from a court, interim relief, which is enforceable, you might still prefer to go to a court. And as we all know, even in India, getting interim relief from a court is fairly efficient and fairly quick. So you don't write off litigation just because you feel that arbitration is the only realistic alternative, but you try and create a right balance between both of them. The other important difference obviously is now with so much cross-border investment, such complex transactions taking place, confidentiality is very key. Obviously in India, confidentiality has always been a problem. The minute you make a filing with FIPB, the foreign investor or even the Indian company would expect that that would be confidential, because your FIPB application will contain a lot of your business plans and what you plan to do. But more often than not, you will find that it appears in the news in a few days' time. But that's the world we live in. We can't help it. Arbitration would give you, obviously, till such time that you challenge an award and you go to court, gives you some degree of confidentiality. That is a very, very important aspect, and actually most clients will choose arbitration because confidentiality of the transaction, the terms of their contracts, what transpired in the hearing is sacrosanct. And if it's in an open court, then obviously you lose a lot of that confidentiality advantage that you have. So that's another, obviously, very important reason. And obviously there are a range of options in arbitration, range of institutions you can choose from, different types of rules, you can write your own rules. So obviously flexibility is high. But at the same time, you have to keep in mind that one size does not always fit all. So you need to ensure that you have the right dispute resolution mechanism thought out and then documented accurately in your contract. And as Payal will discuss later on, that documentation is so critical, because if you look at most of the recent decisions, even from the Indian courts in the Supreme Court, from Balco to Videocon to DOSCO to many other cases, all that time was spent fighting on procedural aspects, not on the merit. Do you have jurisdiction, or is this the right court I should come to? Can I challenge my award here or not? Of course, we'll be spending a lot of time on all these topics, but you could do away with so much wastage of time, effort and money if you had spent much more time in drafting your arbitration or litigation provision in the contract. Quickly skipping to, as I said, this is going to be a general overview of various things that you will hear in the next 2 days. On mediation, a number of times this word will crop up. Some of you will hear it as conciliation, and you'll be familiar with it because we have that in our Arbitration and Conciliation Act in Part 3. So it's a statutory form of mediation. Many of your joint venture partners or your clients or others that you do business with will say, let's have a mediation provision before we actually get into arbitration. So you will say, yes. How do we do the mediation? Mediation will be understood by some as my employee X at certain level will discuss with employee X of yours at certain level, then we'll escalate it to the managing director, and if we are not able to find a solution, then we'll go to arbitration. That may not be the technical interpretation of mediation. That is more of a discussion mechanism that you can build in to try and reach some sort of an amicable solution. It is definitely one way of doing it. But a true mediation is, as you will see on the slide, is when a third party assists the parties who are at difference to reach a settlement. And very interestingly, I had the privilege of participating in a mediation which was conducted by the American Arbitration Association under their rules. And the dispute was between a company and its president. The company was was a US company with an Indian subsidiary. The president was a US citizen who obviously was the president of an employee of both the US company as well as the Indian company. The employment agreement had AAA arbitration. AAA is the American Arbitration Association. It had a AAA arbitration clause in it, but it also had a provision which said that you could go to AAA for mediation before you go for arbitration. That was an option given to the parties. The dispute was with respect to, obviously, he was being asked to leave the company. He had a lot of claims against the company, monetary and otherwise, and he raised a dispute and it went to court in the US, in Los Angeles. And then the parties decided in their wisdom, let's try mediation. So a mediator was appointed from the panel of the American Arbitration Institution, and we went to Los Angeles to participate in that mediation. What was extremely interesting was the role of the mediator. Now, many of us would have, as I said, heard this word. I would say he played the role of a psychiatrist, of a psychologist, more than an arbitrator or a judge or someone who was going to come and tell you that this is what you have to do or that is what you have to do and this is what the law says. The day started off in one room with all parties. Brief discussions took place. There were breakout sessions. He would spend time with only the parties on either side he would spend time with, then the lawyers separately. And as many of you will know, a successful mediation normally lasts only one single day. If it doesn't get over in a day, the chance of a settlement, and statistics show this, is very low. So at the end of the day, at about 6:30 or 7, and we started very early, the parties had actually come to a consensus and signed a settlement agreement. And all that the trained mediator did was get the parties to understand each other's points and try and reach some sort of a settlement. This would never have been possible if a lawyer who was not a trained mediator or an ex-judge who was not a trained mediator would have tried to do this, because it's your mental makeup which would allow you, and the comfort that the parties would have got. So mediation is, in my view, a very important step, especially if you are in a situation where the stakes are very high. Arbitration, though you will hear, is more efficient than litigation, it can still be very expensive. It can still take a lot of time. You have practical problems of challenging awards, and therefore mediation is something which should definitely be looked at as an alternate dispute resolution mechanism. In our Indian scheme of things, you will find a mediation defined in the Civil Procedure Code, in section 89, subsection 2, if I remember correctly. That mediation is different because that is a mediation that is ordered by the court. So you're already in litigation, the court sends you to mediation, you either reach an agreement, and if you reach an agreement, you bring it to the court. If you don't, you go back to the court and say there's no settlement, and the case continues. The closest corollary to international mediation is conciliation in our Arbitration Conciliation Act. You may choose to apply Part 3 of the Act. You may choose to have an international institutions mediation rules. That's up to you. Conciliation under our law, the final settlement agreement which is signed is as good as an award. So it has the same advantages of confidentiality and is binding as an award. So the framework is pretty good. This is what a typical, I won't read the slide to you, but a typical mediation clause could look like. Again, clauses would differ from contract to contract and obviously institution to institution. Again, this is something that most of you have heard at most arbitration conferences, ad hoc versus institutional, and we have speakers from a few institutions here today, so I'm not going to spend too much time in discussing what the differences are, but one thing is certain. In India, we really need to move to a system of institutional arbitration. Whether we have our own institutions, whether foreign institutions come and create substance on the ground over here, all of these institutions can live together. But ad hoc arbitration in a system where unfortunately the judicial system is not very supportive as far as time and efficiency is concerned becomes very difficult. So many contracts still have ad hoc arbitration. So the rules have to be drafted yourselves. The arbitrators don't really have an administrative mechanism that is telling them that they need to finish their hearings in so and so time. So it does create a lot of inefficiency. But at the same time, depending on the nature of your transaction, if it's high stakes, complex, or you just feel that you need an institution, it's better to have institutional arbitration. If it's a smaller contract, you might still prefer to have an ad hoc arbitration. It's really a decision you need to take. But generally, we do not recommend ad hoc to the extent it is avoidable. And obviously, institutional arbitration is highly recommended for the various systems. Also, the rules and procedures, it's less time consuming, and various other. And you can see the recommended institutions. There's so many of them. Some of them are here today in the audience, and they will be speaking on the panels in the next few days. Now coming to a more interesting aspect of it, governing law of contract versus governing law of arbitration. This has been, I would say, if I could say, new development in arbitration jurisprudence globally. We've always been very easy to draft our contracts and say this contract will be governed by the law of India. Great, no ambiguity over there. The arbitration will be as per the Arbitration and Conciliation Act 1996, no ambiguity over there. The seat will be here, again, no ambiguity over there. But from our practical experience, and we also as lawyers and practitioners can only learn from experience, new systems and new interpretations of what the law is, how it is drafted, is there a difference between governing law of contract versus governing law of the arbitration agreement which is within the contract? And if it is silent, then what interpretation is to be taken has become very important. We were recently involved in a matter in Singapore, and before it was an SIAC arbitration, and I think we spent about 4 to 5 days just arguing on what law would govern the arbitration. The contract very clearly said that the substantive law of the contract was Indian law. But the seat of the arbitration was in Singapore. And the question came up as to whether fraud, for example,